Welcome to the Attention Deficit Disorder Expert Podcast Series by Attitude Magazine.
Hi, everyone. It's Susan Kaufman. I'm here for Attitude Magazine's ADHD Experts presentation today. Today's topic is super timely as we head back into school. We're very pleased to have our guest today, Matt Cohen, Esquire, who is an expert on legal rights and special education law. He'll be talking about a very important issue for many of our readers and many of you listening, and that is specifically, what are your legal rights at school? What educational services is your child entitled to under the law, and how should you go about setting up an IEP or a 504 plan? And he's also going to touch on evaluations, testing, and accommodations. Matt is the founder of Matt Cohen and Associates, where he specializes in special education and mental health law. He's a legal commentator for LD Online, a wonderful site, by the way, and serves on CHAD's Public Policy Committee. He's also a frequent contributor to Attitude Magazine, for which we're grateful, and we thank him again so much today for joining us. Today's session is brought to you by ForeBrain, a unique and groundbreaking technology that helps improve attention and sensory processing in both children and adults. For more information, please go to www.forebrain.com. Thank you, ForeBrain, for helping us today. So with that, let me turn it over to Matt, again, with our thanks for being here today.
Hi, thanks for the nice introduction, and I'm happy to be able to share information today that will hopefully be helpful to all of you who are listening. This is an area of great frustration for many, many parents and likely for many educators as well. 30 plus years after both the Special Education Law, the Individuals with Disabilities Education Act, and the Civil Rights Law, Section 504 of 1973 were passed, there is still enormous confusion in the educational and parental community as to what the rights are of children with ADHD. In addition to there being lots of confusion about what those rights are, there are also many places where parents have difficulty getting the services that they need for their children, whether through special education or 504. And in some places, in the aftermath of the recent economic crisis, states are continuing to experience cutbacks in funding that are leading to lesser availability of resources and services. In addition to that, there's a national shift taking place in which there's an effort to move away from individual plan-based services and individual accountability to school-based accountability through things like No Child Left Behind, which is now going to be amended, but which will still represent a continuing shift to system accountability as opposed to accountability for services for particular children. So it's a time of even greater stress in many ways for families of children with ADHD and for those children themselves. The two laws that we'll be talking about today are both very important, very powerful, and quite different in some ways, quite similar in others. The Section 504 applies to all public schools, but is essentially a civil rights statute. The Special Education Law, the IDEA, also applies to all public schools, but is an entitlement law, meaning that if you qualify for the eligibility criteria for a special ed label, then you're entitled to get a free appropriate public education pursuant to an IEP. If you qualify under Section 504 as having a disability, then you're entitled to receive a Section 504 plan. The eligibility for an IEP versus a 504 plan are very, very different, even though they involve similar types of considerations. The first thing to be eligible for an IEP is that you have to have an identified disability, and ADHD is one of the disabilities that's been identified by the federal government under the other health impaired category of the special ed system, which there are 13 categories of disability overall. The second thing in order to qualify for an IEP is that there has to be an indication that your disability results in an adverse effect on educational performance. And this is a place where many schools screen out kids with ADHD on the grounds that they still have average achievement or that their ADHD is not substantially affecting their educational performance. And what schools sometimes say that's incorrect is that academics are the primary measure of educational performance, when in fact, under the special education law, if it's affecting the child's performance at school in any way, including socially, behaviorally, or in terms of just their ability to be organized and on time at school, That's an effect on educational performance as well as the mastery of academics reflected in achievement test scores and grades. So the first thing is that you have a disability, ADHD, that secondly results in adverse effect on educational performance. And third, that as a result of the ADHD, there is a need for special education. This is another place where schools often screen kids out of eligibility for IEPs on the grounds that they don't require special education instruction, even if the disability is adversely affecting their performance. Sometimes schools, on the basis of that decision, shift kids and look at 504 as an alternative, which I'll explain in a minute. And other times they simply say that they're not eligible and don't even consider 504 eligibility, which when that happens is incorrect. But it's also important to know that being in need of special ed instruction doesn't mean that you have to be educated in a special ed classroom. It just means that you need special ed services. By contrast, Section 504 does not require you to have a specific condition that meets one of the 13 categories of disability. It only requires that you have a disability that is a physical or health impairment. That's the first criterion. Second, that it substantially limits one or more major life activities. And if you think about that in comparison to the second criterion for special ed, that's enormously much broader because it covers everything, including academics, thinking, concentrating, socializing, communicating, even being organized or problems with executive functioning might be a basis for qualification. And the third criterion for 504 eligibility is that you need special ed and or related services and or accommodations. This is also a substantial difference from special ed eligibility because under special ed, remember that you need instructional services, whereas under 504, you can qualify if you need instruction or if you need related services such as therapy or if you need accommodations. Many people think of 504 just as an accommodations law because that's the place where many kids qualify under 504 that they wouldn't qualify under special ed. But in fact, Section 504 can also include instructional support and related services. The pros and cons of an IEP versus a 504 plan are various, but probably the single most significant difference is that 504 plans are easier to qualify for and provide for far greater flexibility in relation to what can be done under a 504 plan with far less bureaucracy or complicated procedures that need to be followed. But the very thing that makes 504 advantageous is also a disadvantage because for many kids, they need more structure, they need more support, and an IEP process through the special ed system, which in most states is far more developed, is going to provide a more robust level of service and support than would typically be available under Section 504. So even though Section 504 has the possibility of offering virtually anything that's available under an IEP, it's not required to be offered, and there's no specific regulation that sets out what is required. That leads us to another difference, which is that the mechanism for developing an IEP, how the IEP is written, the requirement for goals and objectives, for measurability, for listing all services and when they start, where they're going to be implemented and for how long and how they'll work, those sorts of details are not present in a 504 plan. That makes 504 more flexible, but it also means that there is far more accountability and direction under the IEP than there is under the 504 plan. So if your child either is complicated and the staff and the child both need more support, or if there's an issue with compliance or follow through or implementation by the school, typically an IEP will give you more ability to hold the school and the staff accountable and give the staff more direction as to what needs to be done than is present in a 504 plan. The other thing that is significant, which I'll be talking about a bit more when I get to some of the other topics for this presentation, is that the procedural safeguards that are present under an IEP are much stronger than they are under a 504 plan. And that's of greatest concern for kids who are having behavioral issues, which, as we know, for kids with ADHD is frequently one of the things that causes them to get attention at school, negative attention rather than positive attention. And the safeguards that adhere to kids with disabilities under the IEP are stronger and more protective than those under 504. So typically, if a child is having behavioral issues, it's better in terms of their own protection if they have an IEP than a 504 plan. But to be clear, 504 plans can cover many of these issues, although the law doesn't specify how they cover them or in what degree of detail. So if a school can be persuaded to provide more detail, that's great. If they can't, then you may need to go with a 504 plan instead. The third thing that I'd like to talk about briefly is some of the specific right to services that there are under an IEP in a 504 plan. And because kids with ADHD have particular vulnerability around emotional behavioral functioning and social functioning, the issue of counseling and mental health services is very important. Under the special ed law, psychology services, social work services, counseling services, even parent counseling and parent training are all related services that are specifically provided for under the law. The fact that they're there and provided for doesn't mean that every kid automatically qualifies for them. So you have to be sure that you are building into the IEP a plan for the services. Another important element of the law for special ed is that it requires that the IEP specify the starting date, frequency, duration, and location. Starting date, frequency, duration, and location of services. And again, in the context of accountability, that's very important. And it's important to think about where will the service take place? Is it individual or group? Is it in class or out of class? How many sessions? And so on. By contrast, under Section 504, 504 does explicitly list counseling services as a related service that can be provided under a 504 plan, which is a good example of the fact that 504 can provide services, not just accommodations. And some of you may have encountered problems with schools saying that all they will provide under 504 is accommodations when in fact they can provide more. So the possibility of related services for mental health and other needs is there under Section 504, but it's not as specific as it is under an IEP, and you want to try to build in as much as you can in relation to the detail of that. The other thing that's important around counseling and mental health services is that some kids with ADHD take medication, many of them in fact, and different states have different rules as to how medication can be administered. But the important thing is that if the child needs an adult, including either an administrator or a nurse, depending on state law, to be the one administering the medication, that can be written in as a related service under an IEP, or it can be written in as a related service under a 504 plan. And in fact, under a 504 plan, if all the kid needs is nursing service to administer the meds, that's sufficient by itself for the child to qualify for a 504 plan without the need for other accommodations or instructional services. So that would be another example of something that's an advantage of a 504 plan over an IEP. Next thing that I'd like to talk about is the issue of procedural safeguards. Again, the special ed law provides far more detail about what the protections are for parents, but essentially under both the special ed law and 504, parents are entitled to notice that the child is being considered. They're entitled to give consent to evaluations, and they're entitled to give consent and to be notified if there's any plan to change the 504 or IEP or to terminate eligibility. However, the degree of requirement for procedural protection under the special ed law is far more extensive than it is under 504 and spells out exactly what types of information you're to be provided, what the timelines are for providing information, and includes things like that you have a right to participate in meetings, that's under 504 as well, but also that you have a right to advance notice to the meetings, to be told what the agenda is, to be told who's going to participate. And even under the special ed law, if a staff member shows up at an IEP meeting who wasn't on the invitation list, you have a right to tell that person that they can't be there if you object to them being there. So that's a good example of the types of safeguards that are present under the special ed law that are not present under 504. Both special ed and 504 give parents the right to request something called a due process hearing. Again, the rules for a due process hearing under special ed are far more detailed than they are under 504. And a very big difference is that under 504, the school appoints the hearing officer, whereas under special ed, the hearing officer has to be an impartial person and is generally appointed by the state as opposed to by the school district. So you get a greater likelihood of a really neutral hearing process. On the other hand, one advantage of Section 504 is that parents can file a complaint directly with an agency called the Office for Civil Rights of the U.S. Department of Education, which is responsible for administering the procedural protections of Section 504. So there are a variety of procedural safeguards under both laws, and importantly, the laws that protect children with disabilities, both of these laws, go far beyond the protections that are available to students who are in regular education without the benefit of these safeguards. So it's very important if you have a child with a disability who's having difficulties to make sure that at least one of these laws is in place. One of these plans is in place, either an IEP or a behavior plan. Fifth thing I'd like to talk briefly about is the issue of behavior and discipline. Again, the IEP process provides more detail about how that's supposed to work than the 504 plan does. One of the notable things that the federal special education law says is that the IEP actually is supposed to consider and include positive behavioral interventions and supports to help a student to avoid having difficulty. And that's something that can be very powerful in helping the student to stay out of trouble and learn more appropriate behavior. That's something that can be done under a 504 plan, but it's not as explicitly mentioned under a 504 plan. The other thing that's important to know under both an IEP and a 504 plan is that children can benefit from both behavioral analysis and a behavior intervention plan, not just to respond to or to mitigate quote unquote bad behavior in the sense of aggressive or acting out behavior, but many kids with ADHD have difficulty with getting to class on time, getting their homework completed, getting things turned in on time, and even just not that they're trying to be disruptive, but raising their hand and calling out in class when they have a question as opposed to just blurting something out. Those characteristics are all symptomatic of the behaviors that are typical of kids with ADHD. They're not things that would typically be regarded as conduct code violations, let alone serious types of disciplinary problems, but they can be very, very disruptive to the student's participation in class, to other students, and can sometimes get them into trouble. And the important point that I want to make about this under both plans is that you can set up a behavior management plan or a positive reinforcement plan under both laws, even though the student is not having disciplinary trouble. So the idea of behavior intervention isn't just intended to be around responding to acting out or aggressive behavior, but any type of behavior that's interfering with the student's functioning at school. One other thing that ties back to the point about mental health services, but also to behavior and discipline, many kids with ADHD also have social problems, limited friendships, transient friendships, difficulty making friendships, and so on. And that's also something that can be addressed as a school-related educational issue under both special ed and 504. The final thing to say about discipline is that, and there isn't time to get into all of the particular procedures related to discipline, but if a kid is having difficulty with behavior at school, especially if they've begun to receive detentions or even worse, suspensions or expulsions, it's very important to use the 504 plan or the IEP to build what I call a behavioral support umbrella. And the idea there is to try to anticipate what are the things that are going to cause the student problems, and to build into the IEP in advance things that will help them to learn appropriate behavior, to identify what skill deficits they have that are interfering with their displaying appropriate behavior, to figure out what things are happening in the environment that may be contributing to or causing problem behavior and modifying those, to help the student to have strategies for managing their behavior when there is a problem so that they can find more appropriate ways to do whatever it is that they're doing. And if there's a problem, find more appropriate ways to deal with it than either acting out and escalating or shutting down, so that they can be managed to return to the appropriate behavior and setting very quickly, and to build in the ways that the staff will intervene with the student that will be more likely to be effective. So the idea of the behavioral umbrella, again, that's something that's my phraseology, by the way, but that's doable under both an IEP and a 504 plan, is to proactively build in things that will help the student that are more likely to keep them out of trouble to begin with, and if they do get into trouble, that are more likely to keep them in a situation where the response is less severe and they're more likely to be able to stay in their existing placement and return to a successful situation as quickly as possible. One other thing about that that's important, though, is that when a child's behavior is related to their disability, the school is not allowed to expel them. When the child's behavior is not related to their disability, they can expel them. And one of the things that the special ed law says that's very important, not specifically in 504, is that one way that behavior will be determined to be related to disability is if the school has failed to implement the IEP appropriately in a way that's related to the behavior. So if you have a good behavior plan and the school didn't implement it correctly, then the child can't be expelled, even though their behavior might otherwise be determined to have been something that they should be expelled for. Final thing that I want to talk briefly about is the issue of accountability in the process. And again, there's more accountability just automatically built into the IEP process than there is under 504. But that doesn't mean that the accountability under an IEP is sufficient or that it's self-implementing. So one of the things that's important about the accountability process is that parents do have a right to participate, have a right to access to the information that's in the child's record, and have a right to seek information about how things are going, because they can't assume, you shouldn't assume, that the school will do what it's supposed to do no matter what. Under a 504 plan, unfortunately, there isn't as much specificity about what accountability is built in, but that doesn't mean that a parent can't attempt to incorporate into the plan specific measures that will help with accountability. So whether it's an IEP or a 504 plan, I encourage parents to make sure that whatever goals or services are detailed sufficiently clearly that everyone understands them, that under an IEP, the goals are written in a way that are measurable, and that the reporting process is clear and can be understood by anybody involved, to build in that information is going to be shared with the parents regularly under both an IEP and a 504 plan, including potentially, could be, depending on the status of the child and their needs, monthly meetings, quarterly meetings. In some instances, I even have parents who are involved in weekly meetings. It could be a weekly or bi-weekly email from the staff to the parent just updating them on how things are going. It could be a phone call under specific circumstances. It could even be an agreement that if something happens involving the child's behavior, that will automatically trigger a call from the school to the parents to let them know what's going on. So there are a variety of ways that can be accomplished. Before we get to questions, I want to just give a couple of very quick tips about all of these things. The first thing is that you know your child better than anyone else does. And in terms of your advocacy for your child, you should not allow people to discount or minimize the information and expertise that you have. On the other hand, you have to recognize that the school staff are supposed to be expert, and whether they are expert or not, they perceive themselves as expert. And equally important, they have an investment in making sure that things run at school the way they want to. So while you have absolutely the correct perception that your child is your highest priority, they're interested in your child, but they're also interested in many other students. And you need to find a way to convey the information that they need about your child without making them feel defensive or that you're doubting their competency. Unfortunately, sometimes those doubts are legitimate, but the more that the conversation can occur in a way that's positioned as supportive rather than confrontational, the better. It's also very important to prioritize your child's needs. There are many, many things that a school can work on in the IEP or 504 process, and the more that you're asking them to do, particularly without prioritization, the more likely it is that they'll decide not to do some of the things or that they will not do some of the things well. So make sure to avoid kind of overwhelming the school with too much in the way of either expectations, demands, or even information. And I would say along those lines, be aware of your rights, be aware of what the plan says and how it's being implemented, but don't sweat the small stuff. There will be always, unfortunately, things that can be found that aren't quite right, but focus on the things that are really critical to your child's success and don't worry about the other. Build in communication with the staff and provide the staff with positive reinforcement and support as well. They're professionals, but they have egos. They have a desire to do a good job. They're under tremendous pressure. And the more that you can work to build an alliance with them, the better. In fact, whether it's with educators, janitors, lunchroom personnel, other parents, and whatever, build allies at school, and promote communication and openness as much as possible. All right, so with that, that's a very, very quick overview of the process, and with that, I'll open it up for questions.
Thanks so much, Matt. That was a huge amount of information. Before we get to this, a number of wonderful specific questions from parents who are having a variety of implementation problems for their children in school, but I wanted to address some of the questions that are here, which are at a more macro level about the law. First of all, these are federal laws, as I understand them. Are there specific laws that people should look for in their states?
Yeah,
is there a state law element?
Absolutely. Okay. On Section 504, because it's a civil rights law, generally does not have specific state law parallels. Mm-hmm. But under the federal special education law, every state is required to have its own special ed law. And there are some areas where the federal law is simply silent. For example, the federal law doesn't say anything about class size or the number of kids with disabilities who could be in a regular class or the credentials that are specific for teachers or whatever. State law says that. The other thing that occurs in relation to the intersection of federal and state law is that state law is supposed to provide or can provide greater protection for kids than federal law does. It's not allowed to provide less protection than federal law does. But because some of these things are subject to interpretation, there are disputes or at least differences and sometimes disputes from state to state as to how they interpret the federal law. So, for example, there are some states that have different rules for what person or clinician is okay to diagnose ADHD for school purposes. So that it's very important to know your state law as well.
Okay. And I guess a follow-up question from a number of people is, where do they find this law? And many of them are saying that, they'd love to see something written down as to what they're entitled to, what the criteria are for services, and they oftentimes find themselves relying on vague statements from the school, which may be things like, he's not disabled enough, or, sort of they feel that there's a lack of tangibility to what they're able to ask for.
First off, and I might have mentioned this, or should have mentioned this at the outset, I do have a book. It's called A Guide to Special Education Advocacy, published in 2009, which goes into a lot of these things in much more detail. That's available from Amazon, Jessica Kingsley Press.
What's the name of it again, Matt? I'll just post that to everybody.
A Guide to Special Education Advocacy, What Parents, Clinicians, and Advocates Need to Know.
Okay.
In addition to that, every state Department of Education or Public Instruction has a website which will certainly include a department or section for special ed, and you can get the state special education regulations from that State Department of Education website. In addition to that, the federal government, U.S. Department of Education, Office of Special Ed Programs, has a website which has the federal IDEA regulations, or even if you just Google IDEA 2004 regulations, you'll get to that. And the Federal Office for Civil Rights has a website that you can also find or Google the 504 regulations.
And I would also say, in addition to Matt's book and others, that on attitudemag.com, we have a number of articles about IEPs and 504s and how to, some very specific, an entire booklet actually last year on how to put one in place with all the steps. So look around the website. And there are other websites as well that have some wonderful resources on this, but it's definitely seems very confusing. There's no doubt about that. On the law itself, another couple of questions. Does it apply only to public schools? So I know this is a large topic, but just in general, does this law apply to homeschoolers or kids in private school to college? What is its scope in terms of a school?
The federal special education law applies to only public elementary and secondary schools.
So K to 12.
Actually 3 to 21.
Okay.
The end date varies a bit by state law, but typically is 21. The start date is age 3. The Section 504 applies to public and private schools, including colleges and universities, but only if they receive federal financial assistance.
Okay.
In addition to that, there's a third law that I haven't talked about yet, but most people have probably heard of it, the Americans with Disabilities Act. And that applies to private schools as well as public schools, but it's different than 504 in two ways. The positive is that it applies to private schools even if they don't accept federal money. So that means it's broader in scope in that way. But the negative of ADA is that it doesn't apply to private schools if they're religiously controlled. So any parochial school would not be covered. So 504 might cover a parochial school if it takes federal money, though many don't. Some do, some don't. ADA would apply to private schools regardless of whether they take federal money, but doesn't cover religious schools.
Okay. So, wow. No wonder people are confused. Yeah. What's the best way for someone to find out what their school, their specific school situation, what law applies to it, whether it be private, homeschooling, parochial?
Well, no, I kind of go back and review that answer because other than whether they get 504, a private school is covered by ADA whether they get 504 or not, whether they get federal dollars. So the only question would be if you're in a parochial school, you're not going to be covered by ADA. You may be covered by 504. Let's say that the school has a Title I reading program or a free lunch program that's federally funded or something like that. That would be fairly well known. But it's hard to find out sometimes with schools. I have a case going at the moment where we're trying to show that a private school is receiving federal funds, but there's no direct funding stream, so it can be complicated.
Okay.
But the key thing is ADA applies to all private schools unless they're religiously controlled, so you don't have to worry about federal money for that. 504 applies if there is federal money.
Oh, got it. Okay. Yeah. And homeschoolers?
Homeschoolers are not covered under either law, except that there is a provision under the special ed law that says that if a child is voluntarily removed from public school to be educated elsewhere, they're entitled to what's called an individual service plan. That's not an IEP, and they have no due process rights, but their local school system is supposed to at least be responsible for evaluating them and can offer services if they have the money to do so. And it's very limited in terms of what they typically offer, but there is a mechanism where you can get some help. You might get speech therapy or some LD resource time or something like that.
Okay.
But the key thing is that there can be service, but it's optional on the part of the public school, not mandatory.
Okay. All right. Let's go to the question of diagnosis. There are some questions about how a child gets diagnosed with ADHD and whether that's the responsibility of the school or the parent. So it's sort of a chicken egg thing. What comes first?
Sure. That's a really important question. Technically, the public school, and this is true under IDEA and 504. By the way, when I say IDEA, I'm referring to the special ed law, so I use those interchangeably as opposed to 504. But under both laws, the schools have an obligation to engage in a process called child find, which means that they're required to find kids who have or are suspected of having disabilities who reside in their school district, regardless of whether the parent has come to the school saying, I think my kid has ADHD, please give them a 504 plan or an IEP. They're supposed to go out and find them. So the responsibility is on them. Unfortunately, for many kids with ADHD, for a variety of reasons, partly confusion about the disability and how it fits legally, partly confusion about the evaluation process, many schools are not as proactive about finding kids with disabilities in general, but especially finding kids with ADHD. So frequently, it's the parents coming to the school and saying, will you evaluate my child? And by the way, a parent always has the right to ask for an evaluation under either law, whether the school has said there's a problem or not. And when the parent makes a request for evaluation, they should always do it in writing and keep a copy of whatever it was that they gave the school requesting the evaluation. So they want to ask for an evaluation for eligibility for special ed or an evaluation for eligibility for 504. And typically, if you ask for a special ed plan and the school decides not to do it, they're supposed to consider a 504 plan as well. But the big question is, does the school team do an evaluation for ADHD or does a private doctor do it? And that's a key thing because under the special ed law, to have qualification, you have to be determined to have a health impairment, which typically people assume to mean that only medical doctors are trained and qualified to diagnose a health impairment. So many schools will typically send parents to say, basically, go get a private evaluation or diagnosis and bring it back to us, and then we'll consider it. In fact, the U.S. Department of Education has said that if the school team uses qualified people who are trained in diagnosing ADHD, like a school psychologist who's experienced with ADHD, they don't necessarily have to have a doctor, but that's a decision that the school should make as a policy issue, not on an ad hoc basis. But the other thing that's tricky is that schools don't really want to pay for outside doctors, and the special ed law provides that you don't have to pay for medical services on an ongoing basis. But both the special ed law and Section 504 do say that special ed and 504 are supposed to be free, and that includes the evaluation process. So if a school says to a parent, go out and get an evaluation outside, the school is supposed to pay for that. If a parent decides to go do it on their own and bring it to the school doesn't have to pay for that. They're obligated to consider any outside evaluation, but they're not obligated or bound by the conclusion of the outside evaluator. However, they shouldn't ignore it, but they have to respond in some way. They could say, we're going to accept it and make the kid eligible. They could say, well, we accept it as indication that there's a problem. We're going to do our own evaluation. Or they could say, well, we've read it, but we just don't think the doctor is correct, and we disagree. But it's a little harder for them to disagree unless they've done an evaluation of their own.
That's amazing. I really didn't know that. And there are 3 or 4 people here who were reporting that, which is why I asked the questions. So Patricia says the school refuses to accept medical documentation from a psychiatrist, stating the psychiatrist will say what the mom wants them to say. And, I find that almost incredible. But you're saying that that's perhaps not put that way, but that does happen.
It certainly happens a lot. And in fact, in fairness to the school district, remember that the criteria for eligibility include how does the disability affect the child's functioning at school, which the school presumably may know more about than an outside clinician. And it includes that the child needs special ed and related services or related services. And presumably the school knows more about whether the child needs special ed or not. So there is.
So parents are really in a catch-22 here because the school needs to weigh in, and yet the school oftentimes declines to take responsibility or to pay for the evaluation.
Right. But one thing that the parents should know, this is a tip for everybody, is that most people are probably familiar with the DSM-4 and 5 criteria as the basis for diagnosing ADHD. And one of the things that a good evaluation includes, in fact, the criteria require, is that the symptoms are observable in more than one of the major settings in which the student functions during the day. And so if we think about that, the kid functions at home, at school, and in the community. So a good evaluation should include feedback from the school staff that document how the child is functioning at school. That's typically done through behavior rating scales that the teachers are asked to complete. And if the teacher rating scales documented that the child was having problems sufficient to justify the diagnosis, I argue that by definition, if they've already documented the suffering or need sufficiently to justify diagnosis, they've also documented the adverse effect at school. Unfortunately, some private doctors don't get that information from the school staff, and then the diagnosis is more vulnerable to challenge. But if the school staff has participated in the data that's being used by the private clinician, they can't very well turn around and then say, oh, it's really not a problem after all.
Right. So just to clarify for the audience, I think what Matt, correct me if I'm wrong here. I think what you're saying is that if the private evaluator gives out rating scales and asks people at school to complete them as part of the diagnostic process, that should help, and then concludes that the child needs services on the basis of information provided by the school, that should help make the case that the school needs to provide services.
It doesn't require the school to accept it. The school always has the right to say no.
No.
But it just puts the school in a position where it's much harder for them to defend that no.
Okay.
If the private doctor has just taken information from the parent and not from the school, then it's very easy for the school to say no by saying, well, we see no, there wasn't any part of that evaluation that included school function.
Okay. All right. So in answer to the question, who's responsible to pay for the diagnosis, it sounds like it depends is the answer.
Well, if the school requires an outside clinical evaluation, they should pay for it.
Okay.
The parent has the option of getting an outside evaluation of their own at any time. If they seek it on their own, then it's their dime.
Right. And then there's a possibility that the school might refuse to.
Correct.
May choose not to consider it.
That's right. Though sometimes even when the school says to the parent, go out and get it, the school may still end up deciding they don't like it. There's one other element to this to mention, which is that if the school does an evaluation, or for that matter refuses to do an evaluation, then the parent has the right to request something called an independent evaluation at public expense.
Okay.
Okay. And the school then has to either agree to pay for the independent evaluation, or if they don't think that it's justified, they actually have to request a due process hearing against the parent to prove that the independent evaluation isn't appropriate.
And is a due process hearing, can a parent represent their child's rights without hiring an advocate? Or I guess there's a question here of people affording the support that they feel that they would benefit from, whether it be an attorney or an advocate of some kind.
This is one of the examples of something that's great on paper but doesn't work so well in the real world.
Right.
In fact, parents do have the right to represent themselves in the due process hearing if they want to. They also have the right in some states, it varies by state, to use non-lawyer advocates if they want to, which sometimes are less expensive than lawyers. But the evidence is pretty overwhelming. I don't intend this as a commercial, but the evidence is pretty overwhelming that the odds of success for a parent are much higher if they have an attorney than if they don't. And unfortunately, the schools have access to lawyers, they have access to more resources, and they have access to far more information because they control all of the school records and they even control actually what's happening in the school environment. So they come into the hearing process with a gigantic advantage. And this is one of the areas where the law is, it's better than nothing, but it still doesn't really address the tremendous differential in the strength of the school versus the parent, right?
Here's Marcy, who's posted, again, these are things which are almost non-believable, and yet they're clearly true. Some teachers refuse to complete the paperwork for the evaluation, which is to your point about controlling all the information and the records.
Yeah. And that speaks to, teachers are overwhelmed. Teachers, some of them are hostile to having kids with disabilities in their classes. They have a lot to do and many competing pressures, but it is part of their job to cooperate in that process. And if they don't, the administrator should be informed. And at worst, in the worst case scenario, that's potentially a due process issue also.
Okay.
And incidentally, a good school evaluation should also include rating scales. So that's whether it's coming from a private evaluator or the school, that should be happening. And if the school tells a teacher to do it, they need to do it. They don't have a right to subvert the process.
Right. Here's someone from a post, which is, I have to say, something I have frequently heard from Attitudes readers. Can the teacher actually approach the parent and say, when are we going to start medicating your child? Or let's just try a small dose and see how it goes. My child is in the second grade and has no 504 IEP. Many parents report to us that they get a phone call from the school in which they say, we think your child has ADHD, we wish you would do X, Y, or Z. Can the school do that? What, in fact, is the school's responsibility in that situation? Certainly not just to say, how about let's try medication? Would that be...
Really, really important question. And it's such an important question, it's such a big problem that in 2004, the law was amended to address this.
Oh, really?
What the U.S. Law says is that the schools have absolutely no right to either recommend or require medication as part of the process of dealing with a child's disability, whatever that is. But this was really, it came up in relation to ADHD. If the school feels that the child might benefit from medication because they have ADHD, they're required to request an evaluation, and the parent has the right to consent or refuse consent to the evaluation. But they can request an evaluation, and if they feel that a medical evaluation is appropriate as part of that evaluation process, with the hope that that might identify the need for medication, they can recommend that there be a medical evaluation. But if they do that, they're required to pay for it. So that's why it's often done informally.
Right.
And from my perspective, and to be very clear, this is my own opinion. This isn't, statute or something. In my opinion, there's no such thing as an unofficial recommendation.
You can't just sort of chat on the side of the
right.
In
If
the
a
hall,
teacher
right.
says, "I think your kid has ADHD," they have an obligation to refer the kid for evaluation. They can't just say, "Go take care of it on your own." Or
Right. Good luck with that.
It's disruptive in class. They should be doing the things that are educationally sound to address the disruptiveness and provide for more support, not, again, just trying to medicate the kid into silence.
So practically speaking then, for this parent in that situation, or for the many parents in that situation, the next step I assume would be to formally request an evaluation with a letter. Is that correct?
The parents, if they're requesting an evaluation, they should always do it in writing and keep a copy. If the teacher is complaining, they should be requesting an evaluation too.
Right. But if they don't, if the school doesn't.
Right. Then the parent should be requesting an evaluation. That's right.
Okay.
And, so it's clear medication works well for many kids, but not all. And the school is obligated to help the child whether they're medicated or not. They cannot predicate the access to service on the kid taking medication.
Yeah, medication is not really relevant, in other words, to whether a child needs services. So in terms of this written letter for that request for evaluation, people listening on the webinar, there are some wonderful sample letters. We have one on the Attitude website in a free download. It's in our section called downloads. If you look in the header of our website, you'll find under school a free downloadable booklet about IEPs that has in it a sample letter requesting an evaluation with the language that you should use. Matt, do you want to talk about what is the time frame on a letter like you send a letter like that? What can you expect to happen and what time frame?
Well, that's actually one of the places where it makes sense to consult state law because there are variations from state to state as to both the procedure for processing it and the timeline.
Okay.
Typically, states do have a timeline in which they're required to respond. Sometimes it's to the request. Sometimes, and this is an important thing for parents to be aware of, is that you have to give written consent for the evaluation after there's been a discussion of what the evaluation will be. And that's different than just requesting an evaluation. So it's a several-step process. The evaluation is requested. The school then decides, is it going to go ahead with the evaluation or not? They then have to discuss with the parent what are the components of the evaluation, and then the parent gives consent to do the evaluation. So there are actually several different time frames. The time frame from the request to that initial discussion, and then the time frame from the discussion to when the evaluation is actually completed.
So there's probably a meeting here where you request the evaluation, then you may meet to discuss it.
Right.
What kind of so then the evaluation may take place. You may need to discuss the evaluation. This is one of the things that I found from working on this and trying to clarify it in the pages of Attitude. And then another meeting after the evaluation comes in which I think, is this right? Oftentimes the recommendation is made, IEP, 504, nothing, whatever the school recommends.
When the evaluation comes in, then there has to be an eligibility meeting, which the parent participates in.
Okay.
And the school may decide the kid's eligible for an IEP.
Right.
The school may decide they're not eligible. If they decide they're not eligible, they're supposed to then also think about 504. But as I mentioned earlier, sometimes schools will say no to the IEP and not even consider 504.
Wow.
And there are many kids who will qualify for a 504 plan even though they don't qualify for an IEP. So parents need to be aware that a no to the IEP doesn't automatically mean a no to 504 because the criteria for a 504 plan are easier.
Right. Okay. So they make the recommendation after the evaluation. The parent may agree or disagree. And then is that a point at which a parent might request a due process hearing?
Yes. And the other side of that, though, there are kids where the school wants to put them in and the parents don't. And when it's the initial eligibility decision, it's important for parents to know they have the right to refuse consent to special ed.
Okay. All right. So the school recommends whatever and the parents don't agree. And
they can say no.
They can say no.
Yeah.
Okay.
But if the school says no and the parent wants it, they can request a hearing under either the IDEA or under Section 504. And that's one of the places where hearings do often take place.
All right. Wow. Just a note here from a listener who said that she was asked multiple times about medication, and it drove her crazy. Once she pointed out the law to them, they never mentioned it again. So that's the law that you just mentioned, that
yes,
medication is not relevant. So folks out there, you don't have to listen to this medication stuff unless they're prepared to request an evaluation, or
again,
there should
be the request for evaluation shouldn't be based per se on the need for of medication. The possibility of medication is an outgrowth of the evaluation.
Right. Okay. Let's see. Maybe we should go to this very interesting topic of behavior. There are a number of questions from parents whose kids have some serious behavior, differences with the school. Our third graders spent part of last year removed completely from the classroom during the first stages of Medicaid, and spending a half day in a classroom expected to do work with anyway. This is a complicated story. I'm not meaning to take this not seriously, but it's hard. And another person whose child is made to stand on the curb during recess because of classroom behaviors. What are their options under special education law?
So, a couple of different things.
The behavior part of this.
So, the first thing would be if they're having behavior and they haven't been given an IEP or a 504 plan yet, the first step would be to seek that out and to argue that the behavior is there. The school may not be recognizing the disability, the ADHD, but presumably then the parent either has an evaluation or seeks an evaluation to say, if the behavior is not occurring in a vacuum, there's a reason for it. We need to find out the reason. If the kid is eligible for a special ed or a 504 plan, then the parent should request that there be consideration of positive behavioral interventions, a positive behavioral plan. They may, as a predicate to that, request that there be something called a functional behavioral analysis, which is a way of observing the child over some hours or days to see what are the things that may be triggering their behavior to better understand it. And then this goes back to the idea I mentioned earlier of a behavioral support or behavioral protection umbrella. The parent should try to build into the plan positive things that can be done that help the child to learn the appropriate behavior, rewards or motivators for demonstrating appropriate behavior, and then strategies or interventions that can be used that will be helpful to the child if there is behavior. The other thing that can be done, and schools sometimes are not happy about this, but is to write into the plan what shouldn't be done. And so something like having the kids stand on a curb, I think that borders on abuse.
Right, absolutely.
And unfortunately, there still hasn't been a formal adoption of abuse protections in the specific context of school, but the child abuse and neglect laws still apply if what the school is doing is especially egregious. And it's possible to build in, if the child does X, the school should respond with Y and Z, but not A, B, and C. And for example, with kids with ADHD, I don't know about what behavior caused the thing that put the kid on the curb, but some kids with ADHD don't like to be touched. Many very good teachers use touch as a positive thing, but if it's a child with sensory issues or reactivity to touch, you build into the plan, don't use touch. Some kids with ADHD get into control issues, and so you build into the plan, don't get into a power struggle or an argument, give them a firm direction and X minutes to control it and, whatever. So you can spell it out what should be done, but as a process of spelling out what should be done, you can also try to build in what should not be done.
Okay. Yeah, these are just shocking comments, really, Lisa. My son was punished. He struggles to start and complete work. He has a 504 plan. He's punished by losing recess. I could not get his teacher to budge on this. Well, how is he going to become more focused by missing recess? I mean, this right. The research is clear on that. Recess. Yeah,
and unfortunately, there is, I think, a huge strain in our society that focuses on the idea of punishment as having value that isn't connected to behavioral change, but really connected to just the idea that you have to suffer consequences if you miss.
Right.
And I think that that's not only not very good public policy, it's not very good scientifically, but it also is contrary to what the law says, which is that the interventions are supposed to be geared to helping the child to improve their behavior. And recess is a classic example where the knee-jerk reaction is no recess, when that's one of the things that's most useful to help the kid to let out some excess energy and to not be as pent up and likely to explode.
Right. How about school communication? Number of people are reporting that it's very hard for them to get information about what's going on in the classroom. Are the accommodations being delivered? How is their child doing? What do you suggest writing in or trying to write in so that communication can be part of the plan?
Yeah, unfortunately, there's nothing perfect because it's all dependent on actual implementation by people. So however detailed it is, people can still ignore it. But even apart from the issue of formal communication, the other thing that I encourage parents to do is to go and observe. And that's not something that you're going to do 5 days a week or even once a week, but it's very useful to get eyes on in terms of what's actually happening. And even though in many classes there'll be kind of an effort to make things look better than they might other days, it's somewhat surprising how frequently things happen that do reflect that there are difficulties occurring. The other thing that can be very helpful is to have an outside clinician go in and observe if the parent has access to a clinician who has some experience with that. In addition to that, in some cases where the implementation is of greater concern, that's an argument for building in more frequent meetings. In some cases, I even ask the school, they don't always agree, but I ask them to engage in some form of documentation of, when and what were the accommodations so that can be tracked. And since the idea is, and this is an important thing for people to be aware of under both laws, accommodations are a way of working around the disability. Accommodations don't remediate the disability.
Okay.
Very important for people, if you've got a skill that the child has difficulty with, you accommodate it as much as you have to so they can manage. But you also want to be addressing the skill so that they're learning so that they don't need the accommodation as much. So you might say that a kid who has homework problems gets an extra day to turn in their homework. That's great because they don't get penalized, but it doesn't help them to turn in their homework on time.
Okay.
So the idea would be that you have to then say, well, in order for me to work on this at home, I want to be clear about what's happening at school. So it can be presented not just as, I don't trust the school, I don't think you're doing your job, but I need this information in order to be more effective in supporting you at home.
Right. Okay. Well, guess what? People are posting that their schools don't allow outside observers.
Yeah.
And others are posting
they should consider FOIA. You can get a copy of the school policy under FOIA, and they should check their state law. Again, this isn't something that's explicit in the federal law, but the federal law the federal courts have said that outside evaluation is a part of the process of parents realizing their rights, including the ability to assess the child at school. So there is precedent for that.
Okay. To your point about remediation versus accommodation, is the law that the school has to help remediate the child's condition?
Well, it doesn't use those words. Those are mine. Yeah.
Yes.
If the child, that's what the whole point of goals and objectives in an IEP, and incidentally, that's a very, very big difference, is that 504 doesn't have goals and objectives.
Oh, okay.
It's another reason that there's more emphasis on accommodation in 504. You can have goals and objectives in a 504 plan, but they're not required. An IEP requires goals and objectives, and the goals are, what is the child to learn? What are we trying to help the child learn to address their disability? So whether you call that remediation, instruction, intervention, or whatever, the goals are the things that we hope that the child will develop the skills to do that they don't have at the moment.
That makes sense. Matt Cohen, I want to thank you so much for being here today. This is a subject that just is so important for everyone. Please check out Matt's book. I think it's, just trying to find the name of it here.
Guide to Special Education Advocacy, What Parents, Clinicians, and Advocates Need to Know.
Okay. You can't do too much reading on this topic to know your rights and to know how to support your children. And good luck to everyone this upcoming school year. Matt, I hope you'll come back soon because this is a topic that we could discuss for many hours, as I know you know.
Great.
Thanks, everyone. And thank you again to 4Brain, our sponsor for this webinar, 4Brain, www.4brain.com. Thanks, everyone, and have a great school year. Bye.
For more Attitude podcasts and information on living well with attention deficit, visit attitudemag.com. That's ADDITUDEMAG.com.
If you're in business, you probably have a website, but can your site handle your growth? How many visitors before your site slows down or crashes? What about storage and data security? From web hosting to virtual servers, Pair Networks provides the online infrastructure you need to start, grow, and flourish. When it comes to security and updates, don't worry, we've got you covered. Our 24/7 US-based customer support is the best in the industry. No frustrating chatbots or sitting on hold for hours. Check out pair.com today to learn more. That's PAIR.com.